And we're back, and we're going to continue our trek to the Supreme Court. But first, we need to talk about types of cases. There are civil cases, there are criminal cases. What's the difference? Well, civil cases are cases that involve monetary damages. They don't usually result in someone going to jail. So broken contracts, breach of contracts, monetary damages, things like that. They don't begin with an alleged violation of the law, typically, though they can. Sometimes there are civil charges filed in addition to criminal charges, but civil trials result usually in some kind of monetary damages being rewarded. All right, so most federal court cases settle out of court with a negotiated agreement between a plaintiff and defendant. This is known in a criminal case as a plea bargain, but this is usually how civil cases are settled too. If the case advances towards trial, there is a process it goes through. This also applies to criminal cases too. First is discovery. Discovery is when each side gets access to information relevant to its suit held by the other side. So we get to see what the other side has so that we can build our argument based on that in response to that. Next comes deposition. This is where attorneys for each side question witnesses for the other side. So sometimes in courts on TV, you may see a lawyer ask a witness a question and then act surprised by the answer. They're totally acting with act surprised. They knew the answer beforehand because they asked the question already during deposition. And they wouldn't be asking the question if they didn't think it made their side look good. So deposition, each side questions the other side's witnesses before it ever gets to court. Outside interest can file friend of the court or amicus curiae briefs stating their concerns in a case. So if a case dealt with, say, gun rights, for example, I would say both the NRA and the Brady Center most likely would issue amicus curiae briefs in which they would argue, here's how we think you should rule in this case, and here's our reasoning for why. Other type of case are criminal cases, criminal procedure, which begin with an alleged violation of the law. Under the Constitution, federal accused criminals in federal courts have the right to an indictment by a grand jury. There is also the discovery and deposition phase happens here in criminal cases as well. Ultimately, over 90% of federal criminal cases are resolved through a plea bargain. What does that mean? That means that the defendant pleads guilty to a lesser charge and receives a lighter sentence before it. Typically, prosecutors will throw the book at somebody. That means charge them with everything they possibly can, even though they know some of the charges probably won't stand up in court or won't get a conviction on. And this will, of course, put pressure on the defendant to issue a plea bargain to something lesser. All right. Either way, once the decision is reached in a district court at the federal level, it can be appealed to a court of appeals. There are 11 appeals courts plus DC and a federal circuit that hears appeals from courts that deal with patents and customs. Usually they hear in 3-judge panels. You can ask them to review en banc if you want. Here is what the Court of Appeals and U.S. District Courts districts look like. As you can see, Tennessee is in the 6th district, along with Kentucky, Ohio, and Michigan. Now, from the Court of Appeals, you can go all the way to the Supreme Court. About 8,000 losing litigants ask the Supreme Court to hear their cases every year. Of those 8,000, about 100 actually get heard at the Supreme Court. Supreme Court's decision to hear a case is purely discretionary. How they decide is this. If 4 justices on the court want to hear a case, then the court will hear the case. Typically, how this works is losing litigants file all their information with the Supreme Court. The Supreme Court justices have their clerks go through these 8,000 cases, weed out the ones they know their respective justice won't want to hear, and narrow it down to a much smaller number, which then is passed on to their justice. Their justice then goes through what's left, chooses what they do want to hear, and throws out the ones they don't, and ultimately is left with a list of some cases they want to hear. The 9 justices then each bring their list of cases they want to hear when they meet, and if one case is on at least 4 of the justices' lists, then it will get heard. That's how it works. only about 1%, less than 1%, about 1%, about 1% of cases that make it to that get appealed to the Supreme Court actually get heard, and 99%, the other 99% of cases, the lower court decision stands. All right. If you get heard by the Supreme Court, here's what you get. Oral arguments, first of all. So each side submits briefs explaining their point of view, and then they get 30 minutes to argue their case in front of the Supreme Court. So the defense and prosecution both get 30 minutes to argue their side of the case before the judges. 30 minutes, this is time. You do not get more than 30 minutes. So you better make your argument succinct and to the point. And here's another fun fact. The 9 justices that are hearing your arguments, they can interrupt at any time they want and ask you a question. And some of them do this more frequently than others. So again, if you spend 10 minutes answering their questions, that's out of your 30 minutes. You don't get extra time because they ask questions. 30 minutes is what you get. That includes any questions you have to ask that they interrupt you to ask. So as you can imagine, if you're a lawyer or arguing a case for the Supreme Court, this can be pretty hectic. This is like the Super Bowl. This is like the Olympics. I mean, if you're a lawyer, this is what you've trained for and worked for your entire life. This is it. So nerves may be a problem here. And also, obviously, if you're making a presentation and someone keeps interrupting you with questions, that can really wreck your train of thought too. But the incentive, though, of course, is to be as clear, concise, and to the point as possible. Leave as little ambiguity as possible, because if there's any ambiguity at all, one of the justices is going to jump on that and ask you about it. So avoid that as much as you can. That will reduce the amount of time you have to spend answering questions, though you probably will have to answer some. Usually these arguments are made available online within a few days of being argued. Within a few days of hearing the oral arguments, the justices meet in conference to vote on the merits of the case and to assign a judge to write the opinion of the court in the case. The opinion explains the court's justification for its decision and set the guidelines for other courts to follow in subsequent cases. If the Chief Justice is in the majority, he or she assigns who writes the opinion. If the Chief Justice is in the minority, then the decision on who to write the opinion goes to the senior judge who is in the majority. These are written, but they aren't released until the end of the court's term. So usually these are kept a very tight secret for months at a time. They rarely ever get leaked ahead of time. The only time I can think of that this has happened was the Dobbs decision, which overturned Roe versus Wade, got leaked before it actually came out, was actually made official. Now, there are 4 types of opinions the courts issue. One is the majority opinion. This is the opinion of a court laying out the official position of the court in the case. So that's basic one. A concurring opinion is opinion written by a judge who agrees with the majority's result. In other words, he agrees that the winning party should have won, but has a different rationale for why. So let's say we have a case that deals with both free speech and freedom of religion. Let's say 5 justices say the plaintiff should win because of freedom of speech. Let's say a 6th justice says, I agree the plaintiff should win, but because of freedom of religion, not freedom of speech. Well, the official ruling of the court is 6-3, but so the plaintiff wins, but the concurring opinion is issued by that one judge. A dissenting opinion is written by judges who disagree with the result reached by the majority as to who should win a case. So the judges who vote for the losing side, the minority, they issue typically a dissenting opinion in which they say, we think this decision is wrong, and here is our reasoning for it. This is mostly a symbolic act. Dissenting opinion has no force of law. Sometimes, though, they can be used. I think in the Brown versus Board of Education case, for instance, the court cited the dissenting opinion in Plessy versus Ferguson. So sometimes when cases get overturned, justices will go back to previous dissenting opinions that are relevant and may cite them. But generally, this is a symbolic thing. A plurality judgment's what happens if the justices or a majority of justices agree on who should win, but they disagree as to why they should win. So the freedom of speech versus freedom of religion one, let's say it's 6-3, but let's say 3 justices say the plaintiff should win because of freedom of speech, and 3 say they should win because of freedom of religion. Well, the plaintiff wins, The majority agrees that the plaintiff should win, but the majority can't agree on why. That would be a plurality judgment. Jobs of the court is to interpret the law, and in doing so, sometimes appear to go beyond interpretation and get involved in policy making. But this is pretty much taken for granted these days, I think. Judges, though, typically base their decisions on legally relevant materials, prior court precedents, plain meaning of the law, and consideration and intent of the framers of the law. And that is going to be all for now. We will come back. We'll talk about criminal justice system in this country, and then we'll be done with the judiciary, and you'll be free to move on to foreign policy. Have a good day.